A for-profit company can claim its religious right to refuse coverage of contraception. That was the Supreme Court ruling today in its long-awaited decision in the case of craft chain Hobby Lobby and its challenge to the birth control coverage mandate in the Affordable Care Act. Combining the highly contentious issues of sex, of religion, birth control, health care, gender equity, and corporate rights, this was the most controversial case of the term, and as usual, the Supreme Court saved its biggest drama for last. In a 5-4 decision, the court declared that for-profit companies of the closely held variety, have rights to religious freedom under federal law, and that those freedoms were substantially burdened by having to provide forms of contraception those companies equate with abortion. Writing for the majority, Justice Samuel Alito announced that protecting the free exercise rights of closely held corporations thus protects the religious liberty of the humans who own and control them. Alito and the court's majority said the government could provide the contraceptive coverage in other ways. In other words, bosses' rights rule. Women workers must wait for the federal government to craft another contraceptive workaround, something White House Press Secretary Josh Earnest said the administration is working with Congress to figure out. And while the court went out of its way to say today's decision only applies to the contraceptive mandate and that it does not provide a shield for employers who might cloak illegal discrimination as a religious practice, all that did not satisfy Justice Ruth Bader Ginsburg. In her scathing dissent, Ginsburg called the majority opinion a decision of startling breadth. Quote, the court's expansive notion of corporate personhood invites for-profit entities to seek religion-based exemptions from regulations they deem offensive to their faiths, raising the question of how the ruling might apply to blood transfusions, antidepressants, medications derived from animals, pills coated with gelatin, and all manner of vaccinations. Justice Ginsburg wrote, the court, I fear, has ventured into a minefield. Joining me now is Consulting Medical Director at Physicians for Reproductive Health, Dr. Ann Davis, President of NARAL Pro-Choice America, Ilyse Hogue, and Truman Capote Fellow at Yale Law School, Emily Bazelon. Ilyse, let me start with you. Practically speaking, what happens next here? Is it ultimately that the American taxpayer is going to be paying for contraceptive coverage?
Well, actually, ultimately, we're going to see women workers having to pay twice, or somebody having to pay twice. I think what was lost on the justices, because none of the tens of thousands of workers whose health care hangs in the balance, none of their stories were present in the Supreme Court. And so people forget, we pay for our health coverage with our labor. There's nothing free about it. So somebody's going to get charged twice if we actually find a solution that keeps these women covered. And as you said, you know, the court found today that corporations are people. There are also people you kind of don't want to hang out with that much, that don't get their medical facts straight, and that don't have any kind of internal logic, since Hobby Lobby covered this kind of contraception before it dropped it to file suit.
The phrase, Emily, corporations are people too, was roundly chuckled at 2 years ago. How far did this decision go in terms of making Mitt Romney's vision come true?
Well, you're of course talking about Citizens United and the court's decision that corporations are people for purposes of giving unlimited campaign donations to so-called independent groups. And this extends that same principle to a different part of the First Amendment and says that corporations are also people for purposes of exercising the freedom of religion.
That's and that is there are maybe 5 or 6 disparate threads here, and I want to pick apart each one with care. Dr. Davis, in terms of the root of this case, if you can call it that, there is the sort of moral and religious issue that the Hobby Lobby has with two morning after devices, the 2 IUDs and 2 forms of emergency contraceptives. They are classified as almost abortion pills from a medical, by those in support of Hobby Lobby's case. From a medical perspective, what makes these pills different than contraceptives, or are they the same?
The medical community has no confusion about what's the difference between birth control and abortion. And women also have no confusion. My patients have no confusion about the difference between the two. So we know clearly that emergency contraceptives and IUDs prevent pregnancy, and that other medications are used for abortion. There's no overlap between those two things. I think sometimes there is hair splitting on the definition of what is a pregnancy.
Right.
But the medical community is also in firm unanimity about what a pregnancy is, and neither the IUD nor emergency contraception has anything to do with abortion. So we use those things to prevent pregnancies, not to cause abortions.
Are you surprised at the amount of misinformation around these pills the morning
I'm
after?
very surprised. I think that if these pills, the way that the pills work is really by preventing ovulation, which prevents fertilization. I don't know how it has gotten so confusing. And
Karl Rove called it an abortion pill just hours after the Supreme Court handed it.
That makes no sense. And when I give my lectures to the medical students on how contraception works, I certainly don't say that we use emergency contraception for abortion. It wouldn't work.
Yeah.
There's no expectation of any effect of that kind. So I think the important thing is to say that when we're having conversations with women in the office, women know what they need. They know they need contraception. And remember that about 99% of women in the United States at one time or another are going to use birth control. So these are really fundamental things that we're dealing with every day in the office. And we want to get our facts right for the patients and make the right decisions.
Ilyse, this is couched, the debate and the analysis over this case tends to be centered on sort of moral and religious issues. Of course, there is a lot of politics that is at the root of this whole lawsuit, effectively. And that a lot of folks said, and I wonder what your feeling on this is today, that the reason this case was coming before the Supreme Court had as much to do with President Obama and the Affordable Care Act and unwinding it or diluting it as much as possible as it did religious freedom.
Well, I think you've got two converging interests here. You've got a organized, well-funded movement who's been chipping away at reproductive freedom for a very long time because they don't actually believe that women should have control over their own bodies. Many of them don't believe women should be having sex. And then you've got a whole host of folks who will look for any place that they can actually poke holes into Obamacare because that is what they live and die for. This is the convergence of those interests. But make no mistake, what the 5 male justices did today was actually say that discrimination against women's health care is not discrimination at all. They took an entire class of Americans, more than half, and said it is okay for your bosses to know better than you do about what we need to take care of our bodies and ourselves. And that is a very dangerous precedent, and there are very powerful forces behind it.
But Ilyse, let me follow up on that, because in some way, doesn't this put Republicans in an awkward position? Those who have supported this and said this is about the religious freedom of Hobby Lobby. Of course, women should have access to contraception. They are then on the record as saying women should have access to health care and contraception and need to figure out the mechanisms by which those things are provided.
Well, many elected Republicans are on the record already voting against contraception, and we're going to make sure that the voters know exactly where their elected representatives stand, because we know the courts aren't going to protect us. We need Congress to do it. That's why voting matters.
Emily, let me ask you, closely held corporations, can you give us your sort of legal interpretation of what that means, and also whether or not you think Justice Ginsburg is overreacting when she says the court may have stepped into a minefield and paints a fairly apocalyptic picture of any corporation objecting to any number of things based on religious or moral grounds?
A closely held corporation is a company that's not publicly traded on the stock market. Over half the companies in the country are closely held. That doesn't mean they employ more than half the employees, because the big stock market companies tend to employ more people. But we're talking about a sizable chunk of the American economy here. Whether a lot of those companies will then try to change the way they treat employees based on religious beliefs, that's just a matter of conjecture. You know, Justice Ginsburg thinks that's a strong possibility because this is the first time the Supreme Court has said that corporations have these kinds of religious rights, and so you'd imagine if the companies see an advantage that they will rush in to take it. I think the other thing that's important that's animating Justice Ginsburg and a lot of the reaction from women's groups is a sense that women and sex and birth control are being singled out for ill treatment here in a way that other medical issues are not.
Do you agree with that, Dr. Davis?
Yes, I absolutely do. I think think that if this kind of activity, these kinds of decisions related to other areas of medicine, there'd be a much bigger reaction and it wouldn't be tolerated. I can say from personal experiences, I've spoken to hundreds and hundreds of women. This is my daily job to talk to them about contraception. And it makes a really big difference whether or not your employer will cover the method. So perhaps someone might think, oh, you know, it's not that big of a deal. You can pay for it out of pocket. I did read one excerpt from the opinion, the dissenting opinion from Justice Ginsburg, who made the comparison that it would be a month's income for a woman who has a minimum wage job to be able to get an IUD. An IUD is about 20 times more effective in preventing pregnancy than birth control pills, and it's something that for some women who have medical problems, they really can't use hormonal contraception. So we're really taking an option away from people that's really going to be great for their health, and there's a lot more interest in the IUD lately, which is great, and a lot more women are using it, and this is really a step backward to say for some women, because of their boss's decision, they're not going to have access to a highly effective method that's very safe. So it's really a big disappointment.
That perspective has been so lost in this entire debate, the women who actually need this, who actually would qualify for this, and what happens to them in the process. Dr. Ann Davis, Ilyse Hogue, and Emily Bazelon, thank you all for your time and thoughts.
Thank you, Alex.
After the